The Honourable, the President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and the prosperity of our nation. Amen.
Oath or affirmation, announcements by the President.
Honorable Senators, I have received the following correspondence from His Excellency the President, Anthony Thomas Aquinas Carmona, ORTTSC. The Constitution of the Republic of Trinidad and Tobago by His Excellency Anthony Thomas Aquinas Carmona, ORTTSC, President and Commander-in-Chief of the Armed Forces of the Republic of Trinidad and Tobago. To Mr. Walid Michael Coppin. Whereas by the provisions of paragraph E of subsection 2 of section 43 of the Constitution of the Republic of Trinidad and Tobago, the President, acting in accordance with the advice of the Prime Minister, is empowered to declare the seat of a senator to be vacant. Now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by the said paragraph E of subsection 2 of section 43 of the Constitution of the Republic of Trinidad and Tobago, do hereby declare the seat of you, Walid Michael Coppin, to be vacant, with effect from the 24th of August 2017. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 24th day of August 2017. The Constitution of the Republic of Trinidad and Tobago, appointment of a senator by His Excellency Anthony Thomas Aquinas Carmona, ORTTSC, President and Commander-in-Chief of the Armed Forces of the Republic of Trinidad and Tobago. Mr. Robert Lee Hunt, in exercise of the power vested in me by Section 42A of the Constitution of the Republic of Trinidad and Tobago, I, Anthony Thomas Aquinas Carmona, President as aforesaid, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Robert Lee Hunt, as Senator with effect from the 31st of August 2017. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 31st day of August 2017. Honorable Senators, I have granted leave of absence to Senator the Honorable Jennifer Batiste Primus and Mr. Daniel Solomon, both of whom are out of the country. Honorable Senators, I have received the following correspondence from His Excellency the President, Anthony Thomas Aquinas Carmona, ORTTSC. To Mr. Ronald Huggins. Whereas Senator Jennifer Batiste Primus is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago, Now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ronald Huggins, to be temporarily a member of the Senate with effect from the 14th of September 2017 and continuing during the absence from Trinidad and Tobago of the said Senator Jennifer Batiste Primus, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 13th day of September 2017. Honorable Senators, I am awaiting one final instrument of appointment, and when that is delivered, we will do a separate swearing in. But honorable Senators are not required to take the oath.
I, Robert LaHunt, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Ronald Huggins, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Honorable Senators, I have received the following correspondence from the Speaker of the House of Representatives. September the 14th, 2017. Dear President of the Senate, establishment of joint select committees. At a sitting held on Wednesday, June the 14th, 2017, the House of Representatives agreed to the following resolution. Resolved, that Mr. Stuart Young be appointed to serve on the Joint Select Committee on Energy Affairs in lieu of Mrs. Ayana Webster Roy. I respectfully request that the Senate be informed of this decision at the earliest convenience, please. Respectfully, Bridget Mary Anisette George, Speaker.
Bills brought from the House of Representatives, petitions, papers.
Minister in the Ministry of Finance.
Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper and supplemental order paper in the name of the Minister of Finance. The Consolidated Audit Financial Statements of Evolving Technologies and Enterprise Development Company Limited for the years ended September 30th, 2015 and 2016. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Telecommunications Authority of Trinidad and Tobago for the year ended September 30, 2009. The report of the Attorney General of the Republic of the Auditor General, of the Republic of Trinidad and Tobago on the financial statements of the Chaguanas Borough Corporation for the year ended September 30, 2011. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Mayor's Fund of the San Fernando City Corporation for the year ended September 30, 2015. The annual report of the Trinidad and Tobago Securities Exchange Commission for the year ended September 30, 2016. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Fair Trading Commission for the 3-month period ended September 30, 2014. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Fair Trading Commission for the years ended 2015 and 2016. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Southwest Regional Health Authority for the years ended September 30, 2008 and 2009. The reports of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Sangre Grande Regional Corporation for the years ended September 30, 2010 and 2011. The second reports of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the North Central Regional Health Authority for the 14-month period and the years ended September 30, 2005, 2006, 2007, and 2008. The reports of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Mayaro Civic Center for the years ended September 30, 2013, 2014, and 2015. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the College of Science, Technology, and Applied Arts of Trinidad and Tobago for the year ended September 30, 2006. The annual audited financial statements of the Community Improvement Services Limited for the financial years ended September 30, 2013, and 2014. The administrative reports of Caribbean Airlines Limited for the years 2010, 2011, 2012, and 2013. The annual audited financial statements of Trinidad and Tobago Free Zones Company Limited for the financial year ended December 31, 2014, and 2015. The reports of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Princestown Regional Corporation for the year ended September 30, 2009 and 2010. The annual audited financial statements of Caribbean New Media Group Limited for the years ended December 31st, 2015 and 2016. The ministerial response of the Ministry of Finance to the 9th report of the Public Accounts Committee on the examination of the report of the Auditor General on the public accounts of the Republic of Trinidad and Tobago for the financial years 2014 and 2015, with specific reference to the Ministry of Health. The consolidated audited financial statements of First Citizens Bank Limited for the financial year ended September 30, 2016. The annual report of Torah Services Limited for financial year ended September 30, 2016. The ministerial response of the Ministry of Finance to the 7th report of the Public Accounts Committee for the 2nd session 2016-2017 11th Parliament on the examination of the report of the Auditor General on the public accounts of the Republic of Trinidad and Tobago for the financial years 2014 and 2015, with specific reference to the Ministry of Education. The ministerial response of the Ministry of Finance to the 7th report of the Public Accounts Enterprises Committee for the second session 2016-2017, 11th Parliament on the examination of the audited accounts, balance sheet and other financial statements of the Estate Management and Business Development Company Limited for the financial years 2008 to 2010. The reports of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Miaro Rio Claro Regional Corporation Chairman's Fund for the years ended September 30, 2013, 2014, 2015, and 2016. And finally, the reports of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Eastern Regional Health Authority for the years ended September 30, 2014 and 2015.
Minister of Rural Development and Local Government.
Madam President, I have the honor to lay on the table the following papers as listed on the order paper and supplemental order paper in my name. And I want to say a special good evening to everyone. I haven't seen you all for a long while. I missed you all. The annual administrative report of the Palo Seco Agricultural Enterprises Limited, PSAEL, for the period October 1st, 2011 to September 30th, 2012. The annual administrative report of the Palo Seco Agricultural Enterprises Limited for the period October 1st, 2014 to September 30th, 2015. The ministerial response of the Ministry of Rural Development and Local Government to the third report of the Joint Select Committee on Social Services and Public Administration, second session 2016 to 2017. 11th Parliament on an existing arrangement and possible option for regulating geriatric care facilities, old age homes. The ministerial response of the Ministry of Rural Development and Local Government to the first report of the Joint Select Committee on Land and Physical Infrastructure on an inquiry into the land tenure issues in Trinidad and Tobago. And finally, the ministerial response of the Ministry of Rural Development and Local Government to the fourth report of the Public Accounts Enterprises Committee for the second session, 11th Parliament on the examination of the audited accounts, balance sheets and other financial statements of the Community-Based Environmental Protection and Enhancement Program, Company Limited, for the financial years 2009 to 2014. Thank you very much.
Attorney General.
Madam President, I have the honor to lay on the table the following papers as listed on the order paper and supplemental order paper in my name, being 6 papers. Firstly, the ministerial response of the Ministry of the Attorney General and Legal Affairs to the first report of the Joint Select Committee on National Security, second session, 2016-2017, 11th Parliament on the follow-up into the status of investigation of the PCA and TTPS into the events surrounding the day of total policing on March 23, 2015. Secondly, the ministerial response of the Ministry of the Attorney General and Legal Affairs to the first report of the Joint Select Committee on Land and Physical Infrastructure, First Ministry of the Session 2015-2016, 11th Parliament, on an inquiry into land tenure issues in Trinidad and Tobago. Thirdly, the ministerial response of the Ministry of the Attorney General and Legal Affairs to the third report of the Joint Select Committee on National Security, second session 2016-2017, 11th Parliament, on an inquiry into operations of the Trinidad and Tobago Forensic Science Centre and the issue of DNA sampling in Trinidad and Tobago. Fourthly, the ministerial response of the Attorney General and Legal Affairs to the second report of the Joint Select Committee on Human Rights, Equality and Diversity on the challenges faced by persons with disabilities and specific focus on access to services and employment. Fifthly, the ministerial response of the Ministry of the Attorney General and Legal Affairs to the 8th report of the Public Accounts Committee, second session of the 11th Parliament on an examination of the report of the Auditor General of the Republic of Trinidad and Tobago on a special audit of the Public Transport Service Corporation, the PTSC. And sixthly and lastly, the ministerial response of the Ministry of the Attorney General and Legal Affairs to the first report of the Joint Select Committee on National Security, second session 2016-2017, 11th Parliament, on the follow-up into the status of the investigation of the PCA and TTPS into the events surrounding the day of total policing on March 23, 2015.
Minister of Foreign and CARICOM Affairs.
Madam President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of National Security and in my name. The ministerial response of the Ministry of Foreign and CARICOM Affairs to the first report of the Joint Select Committee on Land and Physical Infrastructure on an inquiry into land tenure issues in Trinidad and Tobago. The ministerial response of the Ministry of Foreign and CARICOM Affairs on the public examination of the draft summary of the recommendations and conclusions of the 41st meeting of the Council for Trade and Economic Development. The ministerial response of the Ministry of National Security to the second report of the Joint Select Committee on National Security, second session 2016-2017, 11th Parliament, an inquiry into the practice whereby prisoners are granted access to services outside of the prison facilities. The response of the Trinidad and Tobago Police Service to the third report of the Joint Select Committee on National Security, second session 2016-2017, 11th Parliament, on an inquiry into the operations of the Trinidad and Tobago Forensic Science Center and the issue of DNA sampling in Trinidad and Tobago. The response of the Trinidad and Tobago Police Service to the fourth report of the Joint Select Committee on Human Rights, Equality and Diversity, second session 2016-2017, 11th Parliament, on an inquiry into the systems in place to protect children from abuse. And lastly, the response of Trinidad and Tobago Police Service to the first report of the Joint Select Committee on National Security, second session 2016-2017, 11th Parliament, on the follow-up into the status of the investigation of the PCA and TTPS into the events surrounding the day of total policing on March 23, 2015. Thank you.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper in my name. The ministerial response of the Ministry of Works and Transport to the second report of the Joint Select Committee on Human Rights, Equality and Diversity on the challenges faced by persons with disability with specific focus on access to service and employment. I thank you.
Minister of Trade and Industry.
Madam President, I have the honor to lay on the table the following paper as listed on the order paper in my name. The ministerial response of the Ministry of Trade and Industry to the first report of the Joint Select Committee on Foreign Affairs on the public examination on the draft summary of recommendations and conclusions of the 41st meeting of the Council of Trade and Economic Development.
Thank you. Mr. Vice President.
Madam President, I have the honor to lay on the table the following papers as listed on the order paper and supplemental order paper in my name. The 39th Annual Report of the Ombudsman for the year 2016. The response of the Service Commissions Department to the 7th Report of the Public Accounts Committee, second session 2016-2017, 11th Parliament, on the examination of the report of the Auditor General on the public accounts of the Republic of Trinidad and Tobago for the financial years 2014 and 2015, with specific reference to the Ministry of Education. The response of the Personnel Department to the 7th Report of the Public Accounts Committee, second session, 11th Parliament, on the examination of the report of the Auditor General on the public accounts of the Republic of Trinidad and Tobago for the financial years 2014 and 2015, with specific reference to the Ministry of Education. The delegation report on the 42nd Conference of the Caribbean, the Americas, and the Atlantic region of the Commonwealth Parliamentary Association held in Bastia, St. Kitts and Nevis from June 16 to the 24th, 2017.
Minister of Public Utilities.
Madam President, I have the honor to lay on the table the following paper as listed on the supplemental order paper in my name. The ministerial report of the Ministry of Public Utilities to the 6th report of the Public Accounts and Enterprise Committee for the 2nd session, 11th Parliament on the examination of the audited accounts, balance sheet, and other financial statements of the Trinidad and Tobago Solid Waste Management Company Limited for financial year 2008 to 2013.
Minister of Agriculture, Land and Fisheries.
Madam President, I have the honor to lay on the table two papers as listed on the order paper in my name. First, the ministerial response of the Ministry of Agriculture, Land and Fisheries to the first report of the Joint Select Committee on Foreign Affairs, 2nd session, 2016-2017, 11th Parliament, on the public examination of the draft summary of the recommendations and conclusions of the 41st meeting of the Council for Trade and Economic Development. The second paper is the ministerial response of the Ministry of Agriculture, Land and Fisheries to the first report of the Joint Select Committee on Land and Physical Infrastructure, first session, 2015-2016, 11th Parliament, on an inquiry into land tenure issues in Trinidad and Tobago. Thank you.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper and supplemental order paper in the names of the Minister of Community Development, Culture and the Arts, the Minister of Social Development and Family Services, the Minister of Education, the Minister of Health, the Prime Minister, the Minister of Public Administration and Communication, and the Minister of Tourism. The annual administrative report of the Ministry of Community Development for the fiscal year 2011-2012. The annual administrative report of the Ministry of Arts and Multiculturalism for the fiscal year 2014-2015. The annual report of the National Association of Village Community Councils for the period 2009 to 2011. The ministerial response of the Ministry of Social Development and Family Services to the third report of the Joint Select Committee on Social Services and Public Administration, 2nd session 2016-2017, 11th Parliament, on an examination of existing arrangements and possible options for regulating geriatric care facilities, old age homes. A green paper on the draft national parenting policy of Trinidad and Tobago. The annual administrative report of the Ministry of the People and Social Development for the fiscal year 2011 to 2012. The annual administrative report of the National Institute of Higher Education, Research, Science and Technology for fiscal year 2014. The ministerial response of the Ministry of Education to the fourth report of the Joint Select Committee on Human Rights, Equality and Diversity, 2nd session 2016-2017, 11th Parliament, in an inquiry into the systems in place to protect children from abuse. The ministerial response of the Ministry of Health to the second report of the Joint Select Committee on Finance and Legal Affairs, 2nd session 2016-2017, 11th Parliament, on the inquiry into food fraud in Trinidad and Tobago. The ministerial response of the Ministry of Health to the third report of the Joint Select Committee on Social Services and Public Administration, 2nd session 2016-2017, 11th Parliament, on the examination of existing arrangements and possible options for regulating geriatric care facilities, old age homes. The ministerial response of the Ministry of Health to the first report of the Joint Select Committee on Foreign Affairs on the public examination of the draft summary of the recommendations and conclusions of the 41st meeting of the Council of Trade and Economic Development. The ministerial response of the Office of the Prime Minister to the fourth report of the Joint Select Committee on Human Rights, Equality and Diversity into the systems in place to protect children from abuse. The annual administrative report of the Telecommunications Authority of Trinidad and Tobago, TAT, for the period October 2015 to September 2016. The ministerial response of the Ministry of Public Administration and Communication to the ninth report of the Public Accounts Committee, second session 2016-2017, 11 Parliament, on the examination of the report of the Auditor General on the public accounts of the Republic of Trinidad and Tobago for the financial years 2014 and 2015, with specific reference to the Ministry of Health. And finally, Madam President, the ministerial response of the Ministry of Tourism on the first report of the Joint Select Committee on Land and Physical Infrastructure, first session 2015-2017, 11th Parliament, on an inquiry into land tenure issues in Trinidad and Tobago.
Reports from committees.
Minister of Agriculture, Land and Fisheries.
Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The report of the Joint Select Committee appointed to consider and report on the Insurance Bill 2016. Thank you.
Senator Mark.
Thank you, Madam President. Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The fourth report of the Public Administration and Appropriations Committee, second session, 11th Parliament, on an examination of the system of internal audit within the public service.
Questions?
Senator Mark.
Thank you, Madam President. To the Honorable Minister of Energy and Energy Industries, can the Minister state whether he has received an official report from Petrotrin on the alleged discrepancies in production data involving Petrotrin and A&V Oil and Gas Limited?
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, Petrotrin submitted an initial report to me, or update to the Ministry and the Minister of Energy on August 4th, 2017, indicating that there have been recorded discrepancies in the volumes of oil shipped from the Exploration and Production Department to the volumes of oil received at the refinery, and that an internal audit was commissioned and the probe was continuing. I have been advised that the final report, based on the internal audit investigation into this volume discrepancies, has been finalized and will be forwarded to the Minister of Energy for my attention this afternoon. The report was originally submitted from the Internal Audit Department to the President of Petrotrin. Procedurally, what happens after then, it goes to the Audit Committee of the Board for its review, and then to the full Board for its consideration, deliberation, and what course of action should be taken thereafter. That's procedurally how these matters are handled. What happened on the weekend was that this report was leaked, and it is now in the public domain. So the board met urgently yesterday and the day before to consider the findings of the report, and I will be advised on that this afternoon, to my understanding.
Madam President, can the Honorable Minister indicate when this report was completed and why he's yet to receive an official copy?
Minister.
My understanding, Madam President, is that due process was taking place at Petrotrin, because these are some serious allegations that have been made, and procedurally it has to go through these steps what has brought this matter to the fore is the leak that occurred on the weekend, and it has gotten the whole population anxious as to what will be the outcome of it. So what I'm saying is that I cannot breach due process, and due process has occurred, and the report will be submitted to me with a covering letter from Petrotrin.
Next question, Senator Mark.
To the Honourable Minister of Energy and Energy Industries, can the Minister state what steps he intends to take, given the reports of alleged discrepancies in production data involving Petrotrin and A&V Oil and Gas Limited?
Minister of Energy and Energy Industries.
Madam President, the steps I intend to take at present is to let due process take place. As we speak, the audit committee of the board and the board of Petrotrin has considered the report, and they, in their own judgment, will determine what further actions or investigations are needed. At this point in time, I cannot intervene and will not intervene, and I want to be very particular that due process takes place in a matter like this.
Senator Ramdeen.
Thank you, Madam President. Madam President, through you to the Honourable Minister of Energy and Energy Industries. Minister, are you aware that Petrotrin has stopped the payments for the months of June and July, totaling sum of $6 million US to A&V Oil and Gas?
Minister.
I am aware when the audit was being conducted that they had stopped the payment for June and July pending the outcome of the investigation.
Senator Mark.
To the Honourable Minister of Energy and Energy Industries.
No,
Yes. To the Honourable Minister of Energy and Energy Industries. Can the Minister inform the Senate whether the board of Petrotrin has referred the matter involving A&V Oil and Gas Limited to the fraud squad?
Minister of Energy and Energy Industries.
Madam President, at this point in time, it is my information that no such decision has been taken by the board of Petrotrin.
Madam President, having regard to the seriousness of this development, would the minister indicate whether, as line minister, he intends to intervene to direct the board of Petrotrin to have this matter immediately and forthwith referred to the fraud squad?
Minister of Energy and Energy Industries.
As I said earlier, my position is to let due process take its course. When the board makes its official recommendation to the minister, I will deliberate on it and consider what our options are, and I will so decide.
Senator Sturge.
Honourable Minister, in light of what has been revealed, do you intend to take any steps to refer this matter to the Office of the Attorney General, that be the line ministry for the Anti-Corruption Bureau?
Minister.
Senator Sturge, due process. When you are an attorney, you should know that. I am following this thing step by step, and the process, as I indicated, the report was leaked. By whom, we don't know, and it doesn't really matter at this point in time. The process, as I outlined, is in progress, and let due process take its course, and we will determine that in the shortest possible time.
No. Senator Mark.
To the Honourable Minister of National Security, in light of recent violent attacks and open defiance by residents of several communities against law enforcement, what measures are being taken to curb this threat to law enforcement officers?
Minister of National Security.
Thank you very much, Madam President. Madam President, I'm a little disappointed with Senator Mark, because I thought he would have prefaced his question by at least condemning the actions of those citizens who have defied and show open defiance to trying to make the police service. But as someone who have come from a very disciplined environment, having served in the Defense Force for 36 years, I want to strongly condemn the actions of those citizens of Trinidad and Tobago who showed open defiance to the Trinidad and Tobago Police Service, who did show that they did not respect the rule of law and the authority, Madam President. Madam President, I want to warn them also that they can be charged under the Trinidad and Tobago Police Service Act, Chapter 46, 1C, which is this obstruction of the police in the execution of their duties. The Trinidad and Tobago Police Service are hard-working men and women, Madam President, who dedicate their life and their service to this country, and therefore they require the support of all of us in the execution of their duties. To answer the question, Madam President, the Trinidad and Tobago Police Service has advised that the following measures have been put in place. To start, they have in fact continued their investigation and have arrested and charged several persons who have been involved in those incidents. Based on what have happened over the last couple of weeks, they have revised their use of force policy. The use of force policy is actually the principle by which their escalation to react to the minimum necessary force to treat any situation. So they have revised that, and in that revision, they are considering the following: the reintroduction of the use of the baton in addition to the sidearms.
Minister, your time is up.
Thank you.
Senator Sturge.
Honourable Minister, have you been able to ascertain the cause for this behaviour which was directed towards the law enforcement officers?
Minister of National Security.
Sorry, could you please repeat the question?
Have you been able to ascertain the cause of the behaviour which was directed towards these law enforcement officers?
I have not, but it certainly is a case of indisciplined actions to law enforcement, a failure to recognize authority and law enforcement in Trinidad and Tobago.
Have not. Do you have any intention of trying to ascertain the cause of what transpired?
That is a job for the Trinidad and Tobago Police Service and Police Commissioner. I can also add that the Commissioner of Police and the Trinidad and Tobago Police Service, in looking at measures, they are in fact, as I said, considering the use of non-lethal weapons in terms of, as I said before, the use of the baton, together with the sidearms in those kind of situations, the use of taser, the use of pepper spray, and so on, non-lethal weapons, in addition to the equipment that they use at this point in time.
Honourable members, the time for urgent questions has expired.
Questions on notice?
Leader of Government Business.
Madam President, the government plans to answer all questions as listed this afternoon.
Senator Ma.
Thank you, Madam President. Question number 95 to the Honourable Minister of Finance.
Leader of Government Business.
Madam President, in response to question 95A, TSTT has advised the Ministry of Finance that it conducted appropriate due diligence prior to the acquisition of Massey Communications Limited. And the answer to section B of the question is no.
Madam President, can I ask the Minister what were the elements of the due diligence that was conducted by TSTT in its acquisition of Massey Communications?
Minister.
Madam President, I have not seized of all the details, but I am making a commitment to revert to Senator Mark at a later date.
Madam President, could the Honourable Minister indicate whether any valuation reports were done by TSTT before they acquired the assets of Massey Communications?
Minister.
My understanding, Madam President, and the answer to that is yes.
Madam President, could the Honourable Minister indicate whether those reports due diligence as well as the valuation reports in the interest of transparency and accountability would be tabled in this Honorable Senate for public consumption?
Madam President, I cannot give that undertaking. As we speak, there's an issue which is being looked at as to whether TSTT should have submitted due diligence and valuation reports to the Ministry of Finance prior to the acquisition. And related matters, such as whether agreement of the Minister of Finance was required before the acquisition took place, that is currently under review by the Investments Division of the Ministry of Finance.
Madam President, is the Minister aware that the equipment that would have been purchased would have been 5 years and over, and whether it would not have been more profitable for TSTT in a fast-paced technological world to have purchased its own equipment to upgrade its operations?
Senator Mark, that question does not arise.
Oh, it
Next
does not.
question, Senator Mark.
May I ask him whether he has any idea?
No, next question.
Yes, I'm asking.
Yes.
I'm
No,
asking.
next question. Next question.
Oh, you mean I've exhausted?
Yes.
Oh, my God. Was not aware. Thank you very much, Madam. The next question is directed to the Honorable. Anyway, question number 101 to the Honorable Minister of Education.
Minister of Education.
Thank you very much, Madam Speaker. Madam Speaker, students and staff of the Pesal Government Primary School complained of noxious odors emanating from the sewer system. The Educational Facilities Company Limited, EFCL, engaged their in-house engineers and technicians to troubleshoot and conduct an assessment to remedy the issue. EFCL determined that the plumbing system consisted of aged and deteriorated cast iron plumbing that had become porous and may have contributed to the escape of inorganic gases. Such inorganic gases that contain compounds such as hydrogen sulfide and ammonia. This would have contributed significantly to the noxious odors. Additionally, EFCL determined that the grading of the discharge piping and inadequate venting was a contributor to the foul odors. The repair works commenced on the 30th of August 2017 and were completed on September the 2nd, 2017. The repairs conducted will negate the effects of noxious odors and discharge of untreated effluent in the environment. Thank you.
Madam President, could the Honorable Minister indicate whether he's satisfied with the repairs conducted and therefore there should not be a repetition of the noxious odors emanating from that particular area of that school, Mr. Minister?
Madam President, the information that is before me from EFCL engineers would indicate that they were satisfied with the work that was done, and as a result of that, I also am satisfied. Thank you.
Senator Ma.
Madam President, through you to the Honorable Minister of Education, could you provide this Honorable Senate with the final cost of the repairs that was conducted to this particular system? Could you provide us with it?
Senator Mark, that question doesn't arise from the question that was next. You have two more supplementary.
Could I ask the Honorable Minister whether he can provide us with the contractors that were involved in this repair exercise?
Also does not arise, Senator Mark.
Doesn't. And Madam President, is the minister, can the minister give this Parliament the Senate the assurance that, given the reports that were submitted, that school would not be subject to further dislocation because of that situation you have just outlined.
Minister of Education.
Madam President, I just indicated to this House that the report I received from EFCL's engineers would indicate that they were satisfied that the work was done satisfactorily. Thank you.
Next question, Senator Mark.
Thank you, Madam President. Question number 102 to the Honorable Minister of Rural Development and Local Government.
Minister of Rural Development and Local Government.
Madam President, I thank Honorable Senator Mark for his question. During the recent National Cleanup Campaign initiated by the Ministry of Rural Development and Local Government, the Couva, Tabaki, Talparo, and the Princeton Regional Corporations assisted with clearing and cleaning parts of Garakara River, the Williamsville River, which is a tributary to the Garakara River, and other rivers linked to the Garakara River. This is a main watercourse, and as such, it is not within the purview of the Ministry of Rural Development and Local Government, but we continue to collaborate with the Ministry of Works and Transport Drainage Division to address all issues faced by the burgesses of the country. The Princeton Regional Corporation assisted the Ministry of Works efforts upon a request from the Drainage Division by providing labor to clean the river banks. Thank you.
Senator Mark.
I don't know if the Honourable Minister could advise us as to the huge garbage pile-up that was left after this so-called cleanup campaign in Williamsville, whether that matter has been addressed by your ministry or the regional corporation, or a combination of both.
Minister.
Thank you again, Madam President and Senator Mark. With respect to the garbage pile-up in the community of Williamsville area, much of it resulted from debris being washed down in the aftermath of Tropical Storm Brent. To address this issue, the Princeton Regional Corporation deployed resources to the community, and during the period June 20th, 2017 to July 5th, 2017, the corporation carted, loaded and disposed of 20 truckloads of spoil, which was separated and apart from the routine scavenging service. I am pleased to inform that in August, all areas in the Williamsville district have been addressed, resolving the pilage of debris and garbage. All corporations have bulk waste pickups along with their regular garbage pickup that occurs on Mondays, Wednesdays, and Fridays. Citizens can contact the Public Health Department of the respective corporation for bulk waste removal. This is a proactive approach taken by all corporations to manage waste collection and speaks to the individual level of responsibility and management that makes up the spirit of local government.
Madam President, through you to the Honourable Minister, would you want to share with this Senate the cost of this cleanup exercise in removing what you have just identified and which contractor might have been involved?
Senator Mark, that doesn't arise. That's a completely different question. Can you ask another question?
I think I'll have to put it in writing.
Sure.
Yeah. May I go on, sir?
Yes.
Question number 103 to the Honourable Minister of Education.
Minister of Education.
Thank you very much, Madam President. Madam President, the 2017 July-August Vacation School Repair Program was implemented by the Education Facilities Company Limited. Thank you.
Madam President, through you to the Honourable Minister, is the Minister aware that a meeting called by him and the local government minister at his ministry, in which several corporation leaders were summoned, a decision was taken to ask local government to deal with the repairs of school during the school vacation period. Are you aware of this, Mr. Minister?
Minister of Education.
Madam President, I'm aware that a meeting was called. I am not aware that a decision was taken. That meeting was called to discuss the possibility of the regional corporations effecting those repairs. The regional corporations indicated to us that they were not ready at this time to effect those repairs. Thank you.
I ask the Honourable Minister again, through you, whether it is the intention of his ministry and maybe the government to utilize the services of local government in the not too distant future.
It is in the Local Government Act.
To conduct those repairs of schools that are currently done by the Education Facilities Company. Could you share with the Senate whether that is the intention?
Minister.
Thank you very much, Madam Speaker. It is the intention of this government to engage the local government authorities in all aspects of work that will involve the local communities. Thank you.
Madam President, do you have one more?
Two more.
Two more. Could I ask the Honourable Minister whether the ministry is contemplating effecting the measure that you have outlined in the next period, meaning the next year between the months of June to September, when school vacation would normally take place. Is it the intention of your ministry to effect the measure utilizing local government services for the repairs of schools? Madam President.
Minister of Education.
Madam President, Senator Mark always confuses me with his questions. On the one hand, he asks one question, and in the same breath, he asks another question. His first question was whether we are contemplating. Then he said whether we have taken a decision. Two different questions. I can answer the first one. Madam President, yes, we are contemplating to involve local government bodies as part of our local government reform. This is an initiative of this government, and it is part of our official government program and policies. Thank you.
Therefore, Madam President,
that's 4 questions.
Logically follows. No. The President is in charge here. You take instructions from the President. So may I ask the final question? Whether the government, is in fact going to replace local government, right? Is going to replace rather the Education Facilities Company in fiscal 2018 by the utilization of the local regional bodies to effect repairs of school. May I ask that question of you?
Now that question, because it has been asked in different ways prior. Senator Richards.
Madam President, through you, if I could just request a status update on the deferred question 118 to the Minister of National Security, which a written response was due by the 8th of August.
Senator Richards, as I understand it, that question is not deferred, and it is going to be circulated.
Circulated during
the
the
Minister
course
has
of
indicated they're in a position to answer all the questions, oral and written.
For leave to move the adjournment of the Senate on definite matters of urgent public importance.
Senator Ramdeen.
Thank you, Madam President. Madam President, I hereby seek leave to move the adjournment of the Senate today under Standing Order 16 for the purpose of discussing a definite matter of urgent public importance. That is, the failure of the government, and more particularly the Ministry of Energy and the Board of Petrotrin, to take steps to address the discrepancies in production data involving Petrotrin and A&V Oil and Gas Limited. The matter is definite because it pertains specifically to the actions of one operator, A&V Oil and Gas Limited, and one particular production field, the Cats Hill production field. This has resulted in Petrotrin paying royalties to the government of approximately 1.86 million United States dollars for crude oil not received during the period January 2017 to June 2017. The matter is urgent because the operator, A&V Oil and Gas Limited, continues to operate the Cats Hill field and continues to receive payments from Petrotrin. Despite the completion of an audit report since the 17th of August 2017, no steps have been taken by the government or the board of Petrotrin to implement the recommendations set out therein. The matter is of public importance because as a country at this time, we cannot afford to continue to lose tens of millions of dollars in foreign exchange. If this matter is not addressed forthwith by the government in a transparent and open manner, the ability of our country to attract foreign investment will be adversely affected. I thank you.
Honourable Senators, I am not satisfied that this matter qualifies under this standing order.
Public business, government business, bills, second reading.
Honourable Senators, as I indicated earlier, I want to revert to the earlier business on the order paper. I am now in receipt of the instrument of appointment. The Constitution of the Republic of Trinidad and Tobago, by His Excellency Anthony Thomas Aquinas Carmona, ORTTSC, President of the Republic of Trinidad and Tobago and in Commander-in-Chief of the Armed Forces, to Ms. Sharla Alexander Dollaby. Whereas Senator Daniel Solomon is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Sharla Alexander Dollaby, to be temporarily a member of the Senate with effect from the 14th of September 2017 and continuing during the absence from Trinidad and Tobago of the said Senator Daniel Solomon, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 14th day of September 2017. Honourable Senators, a senator is required to take the oath.
I, Sharla Alexander Dollaby, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Public business, government business, bills, second reading.
Attorney General.
Thank you, Madam President. Madam President, I beg to move that a bill entitled An Act to Abolish Preliminary Inquiries and to provide for the pre-trial procedure in respect of indictable offences and for ancillary matters be now read a second time. Madam President, it's good to be back in the Senate. We have the pleasure of resuming the business of the country in this August chamber after having had the mandatory recess. Prior to the going off on recess, we certainly engaged in a considerable amount of heavy work, which I wish to thank all senators opposite, independent bench, and those on our side for. Certainly it was a very enjoyable experience to participate in the very fulsome work that we did together as a Senate. Today we propose to start and listen carefully to the proposal for the replacing of a system of law which has stood upon the books of Trinidad and Tobago now for 100 years. The law dealing with preliminary inquiries is to be found in Chapter 1201, the substantive law, which is the original law standing in place, is the Indictable Offences Preliminary Inquiry Act, Chapter 1201. That was started by an Act of Parliament, Act number 12 of 1917. That law has been amended 21 times to date, last amendment being in 2014. But we have had in the experience of pre-trial procedures in making sure that there's an adequacy and a fairness of process, we have had several experiments with law. It's time for us now to take stock of where we are, what the systemic roadblocks are, and what solutions ought to be applied to deal with the number one issue in this country. And the number one issue for all of us, for all parliaments, this now being the 11th Republican Parliament, for all of us citizens has been grappling with the issue and scourge of crime and criminality. The work which we did in the session prior to the mandatory recess just had in July and August centered around the criminal justice system in large part. We sought to debottle, we sought to decant, and we sought to improve the criminal justice system in a number of ways. We looked to removing the near 100,000 cases in backlog to deal with trafficking offences under the Motor Vehicle and Road Traffic Act. We've looked to deal with the situation of persons who are remanded into custody who cannot access bail, the vast majority of whom have stood there for a very long time and who are arguably being introduced and indoctrinated into a system of criminality in a rather unconstitutional setting, which many of our prisons reports have acknowledged. And judges, if we look to Justice Gobin in the Edgell case. We sought to deal with the introduction and improvement of an improved system for plea bargaining. We have sought to deal with the introduction of trial by judge only in certain circumstances. And we did so because we did an analytical appreciation of where we are as a country. So perhaps I ought to start immediately with the statistical position of where we are. Let me start by saying that there are 3 laws on the books of Trinidad and Tobago to deal with preliminary inquiries. The first one is, of course, Chapter 1201, which I've just referred us to. The second one is the Administration of Justice Preliminary Inquiries Act, 2011, which was partially proclaimed, as we're well aware. And the third one was the Pretrial Procedures 2014 legislation, which we dealt with as a parliament in a replacement model for the 2011. That's officially the Indictable Offences Committal Proceedings Act 2014. Statistically, it's important to start with what our country is facing. I asked for and obtained some of the statistics passing through our courts. Let's start with what our courts are comprised of. As we know, we've recanted some of these before, but it's important to put it onto this particular point when we look to proportionate aim. We have 50 magistrates sitting currently in Trinidad and Tobago. There are 12 magisterial districts. The Supreme Court bench is comprised of the Chief Justice, 10 Justices of Appeal, 31 puisne judges, and 3 masters. When we look to the throughput in the magistracy in particular, where the magistracy is the body charged with the administration and implementation of pretrial procedures in the form of Chapter 1201, the preliminary inquiry route, the case throughput is very interesting. In the last annual report, which reported on the 2014-2015, the following magisterial districts had the following annual caseload. Arima, 75,796 cases. Chaguanas, 41,809 cases. Couva, 19,729. Mayaro, 10,872. Point Fortin, 17,173. Princestown, 33,291. Rio Claro, 8,277. San Fernando, referred to as the Old Court, 24,180. San Fernando, the Medina Building, 24,667. Sangre Grande, 30,964. Siparia, 29,951. St. George West, 151,812. Tobago, 23,227. Tunapuna, 35,293. That's a total of 527,043. These figures coming from the annual report for 2014-2015 reporting year. Now that obviously includes the whole array of cases that come. Petty civil, traffic cases, indictable offences, etc., which are to be dealt with by preliminary inquiry. When we look specifically to the matters that are standing in the magistracy at the preliminary inquiry stage, we notice that of the criminal matters pending at the Magistrates Court as at July 31st, 2015, and we did that because these are reported figures, there is a total of 29,090 cases standing as at that date. The opening of the law term will be next week. We expect to get renewed figures on these points, but suffice it to say, we are at 29,090 matters. Number of matters pending per category type. Murder, 417. Attempted murder, 300. Kidnapping, 439. Arms and ammunition, 5,788. Sexual offences, 3,597. Narcotics, 5,758. Fraud, 5,407, etc. What's important to note when we deal with crime and criminality and trying to eradicate that scourge is that there appears to be in our country a perception appreciated as a reality for the vast majority of citizens that if there is a crime committed, yes, you may go into the judicial process, but you're taken into a process where the delay is so significant because of the design of our criminal justice system that justice is definitely going to be delayed, and therefore there is no consequence to crime. We had a horrible murder, for example, committed on a true patriot of Trinidad and Tobago, Dr. Claire Broadbridge. The police went to work. I understand that this morning 2 persons were brought before the court. That may be one event. We congratulate the Trinidad and Tobago Police Service for acting swiftly in a particular matter, or for bringing home a child who was kidnapped, or for charging persons involved in a well-known kidnapping in San Fernando. But what happens next is the subject of this debate. The statistics now that we know that the 29,000 orders at a particular year continue in this regard, Madam President. When we look to the number of first hearings for the same category of matters that I've just described, murder, number of first hearings in the particular year, let's take 2014, 2012, 2013, 2014. I just described the figures in the hundreds. Number of first hearings for murder, 4 in 2012. For 2013, 3. For 2014, 4. January to July 2015, 5. So a total of 16 first hearings. Attempted murder, 2012 to January and July 2015. Attempted murder first hearings, 5 for 2012. 4 for 2013. 4 for 2014. Let's look to sexual offenses. Of the thousands that I just referred to, number of first hearings for sexual offenses, 112 for 2012. In 2013, 41. In 2014, 104. January to July 2015, 39. Let's look now to the time that these matters stand in the particular disposition matter. Let's look at the disposition of matters across the number of years that they stand. When we look to the figures, we can see that the disposition of matters is one which causes great concern. When we look to the number of matters that are beyond, let's look at the full schedule, and permit me just to pull it up, Madam President. When we look at the category of offenses, sexual offenses, for those under 3 years, there are 131. But for those over 10 years, there are 120. That's of the 355 I reported. For murder, there are 160 under 3 years. But for those beyond 10 years, there are 126. For offenses against a person over 10 years, 213. For manslaughter over 10 years in the court system, 13. Attempted murder, 50. Firearms, 113. Dangerous drugs, 49. Other offenses, 496. When we look to the number of offenses in the magistrate's court, which are beyond 14 years, for example, there is a statistical occurrence of at least one matter beyond 14 years in the magistrate's court for murder. For arms and ammunition, 20 beyond 14 years. Sexual offenses, 2 beyond 20 years. When we get down to the period 9 to 10 years in sexual offenses, there are 12 outstanding. Above 5 years, there are 114 outstanding. Now let's translate some of these statistics into the human incident. For every sexual offense, there's a perpetrator alleged so to be. There's a virtual complainant in that category. There is a complainant who's the police officer coming to court. There's a prosecutor at the DPP's office or at the Trinidad and Tobago Police Service. There's forensics which feeds in, but there's a victim. And the victim of a sexual offense going to court in the magistrate's court for over 14 years is in and of itself a tragedy. We are dealing with the phenomenon of witness intimidation, witness tampering, death of witnesses, death of the prosecutor, loss of file, loss of interest, loss of hope. And when we come to these kind of statistics and we start to talk about preliminary inquiries and proposals for a new system for pre-trial procedures, the government has now approached this Parliament on the 22nd occasion of proposed amendments to this now 100-year-old law to say that we have tinkered with pre-trial procedures, preliminary inquiries, in particular in a significant way in the year 2005 and 2008, when we sought to introduce written statements, etc. That door was opened wide because cross-examination was permitted, and therefore the entire system of pre-trial analysis fell into the arrears that we now see in the statistics. In 2011, the then government, now opposition, came to the Parliament and proffered a system of pre-trial procedure which involved initial hearings and sufficiency hearings based upon the St. Lucian model, where they said, let us appoint masters of the court to consider these committal proceedings, see if there's a sufficiency of evidence, and if there is a sufficiency of evidence, then have it referred to the High Court for disposal or to the summary court or entirely off the case. In 2014, due to inefficiencies in the 2011 bill, an entirely new model was proposed by then government, now opposition, which was offered on the back of the Antiguan model, where instead of using masters of the High Court, magistrates were then employed to have a view of the sufficiency of evidence coming before them, in a similar system of doing the two purposes that committal proceedings were designed to do, and that is, of course, to allow for the disclosure of evidence and then the probing as to the sufficiency of evidence. Those are the two purposes of pretrial proceedings. But in dealing with that, we found ourselves in a position where the operationalization of that law was not built upon the back of the statistical appreciation of where we are or not. This bill which we have on offer before the Parliament is specifically intended to treat with elimination of a step of procedure which is not grounded in constitutional right at all, which is not grounded in any finding of guilt or innocence at all, but which is instead grounded in the Director of Public Prosecutions having the responsibility to consider whether a charge ought to be dealt with indictably, and if so, proceed to the High Court, or summarily, and if so, proceed to the Magistrates' Court. In dealing with that process, the bill sets out 43 clauses, 4 parts. The first part is the preliminary part, clauses 1 to 5. The second part deals with search warrants and summonses and warrants in general, clauses 6 to 13. The third part deals with pretrial procedure, which is the nuts and bolts of this, which is clauses 14 to 38. And then the last part has some important reflections as to miscellaneous matters, including important amendments to coordinating laws with this. The government proposes in the legislation that the best part of the preliminary inquiry's existing law obtains. The existing preliminary inquiries law has been in effect since 1917. We say maintain the provisions which treat with warrants, summonses, the operationality of justices of the peace, of magistrates with concurrent jurisdiction, etc. In fact, if we do a cross-reference between the existing Chapter 1201 and we deal with this bill, one can easily note that Clause 4 of the bill, dealing with justices of the peace, etc., is very similar to Section 2 of the original Act. That is the Preliminary Inquiry Act, Chapter 1201. Clause 5 is in similar provisions to Section 3 of the existing law. Clause 6 is similar to Section 5 of the existing law. Clause 7 is similar to Section 6 of the existing law. When we go down to Clause 8, we are looking to a similar section to Section 8 of the existing law. Clause 9, which deals with the issuing of summonses, deals in similar terms to Section 7 of the existing law. The provisions for warrants in Clause 10 of this bill deal with the similarity of provisions in Section 9 of the Act. In Clause 11, where we make a first departure, which I'll explain in a moment, we're dealing in similar terms for warrant matters brought before a magistrate, as is contained in Section 10 of the preliminary inquiry's existing law. Clause 12 is similar to Section 11 of the Parent Act. When we deal with the processes, of course, we have some deviation because we're not proposing that the magistrate engage in any form of preliminary inquiry investigation. Instead, it is anchored to the DPP's purpose, and I'll come to that in a moment as to constitutional grounding for that. When we deal with the admissibility of statements, we're looking at Section 16C of the existing law, and that would be Clause 17 compared to Section 16C. When we look to Clause 18 of the bill, we're in similar terms to Section 19 of the Preliminary Inquiries Act. When we deal with notice of alibi in Clause 19, we're dealing with similarities between Section 16A and B of the existing law. And when we deal with the preferral of indictment in Clause 22, which is an important section which I'll come to, we're looking at similarities in Section 25 of the existing law. Similarly, Section 23, Clause 23, again finds rooting in Section 23 of the existing law. When we look to Clause 24, which is lost or destroyed documents, we're looking at Section 26.2 of the Act. When we're looking at fresh evidence, which is clause 25, we're in similarity to section 17.7 and section 24C of the existing law. When we look to clause 26, with the DPP's referral back for matters to be dealt with summarily, we're looking at the existing law, section 27.2. The committal for sentence in clause 27 is similar to sections 27A, 27B, and 27C of the existing law. The recording of the answer of the person, of the accused person in clause 28 is similar to 17.2 of the existing law. Bail on committal for sentencing in clause 29 is similar to section 30 of the Act. Clause 30, which deals with conveying the accused person to prison, is similar to section 31 of the existing law. Clause 31, bailing the accused person for committal, is similar to section 32 of the existing law. Clause 32, where a judge grants bail, is similar to section 33 of the Act. Clause 33, apprehension of accused person on bail about to abscond, is similar to section 34 of the Act. Clause 34, the power to revoke or require higher bail, is similar to section 37 of the Act. Clause 35, place of committal, is similar to section 38 of the Act. Clause 36, pre-trial requirements, the DPP to give registrar notice, etc., is similar to section 21.7 of the Act. Clause 37, reading of statements at trial, similar to section 39 of the Act. Clause 38, restriction on publication and report, is similar to section 41 of the existing law. Part 6 of the Summary Courts Act to apply, where we refer to Chapter 420, of course, is similar to Section 23F of the Act. And the rules of court provisions in Clause 24 are similar to Section 16B6 of the existing law. And then we deal with the matters of transitional and consequential amendments. Now, I've taken time to refer to the similarities between the bill and the existing law upon the premise just stated that we're seeking to hold and keep alive the provisions of the preliminary inquiry law, Chapter 1201, which have worked well. Let me now translate what we're dealing with when we look to the office of the DPP having this responsibility for looking at whether a matter should be dealt with indictably, and if so, his power to refer the matter to the High Court as the pretrial procedures, beginning at Section 11, really starting in heart at Clause 14, Clause 11, in heart at Clause 14, continuing on in Part 3, really prescribe. Madam President, I wish to refer firstly to the importance of the supremacy of the Constitution of the Republic of Trinidad and Tobago. Section 2 of the Constitution describes the Constitution as the supreme law of the land, and the Constitution in particular sets out certain enshrined rights, as we're well aware, in sections 4 and 5 of the Constitution, in particular the right to fair trial and the right to essentially due process of the law and procedural fairness. These are concepts and flavors without going into the particular language of sections 4 and 5, guaranteed that that is trite in terms of the translation that I've just given. But when we get to the heart of the Constitution, in dealing with Chapter 6 of the Constitution, it's important to note that the Director of Public Prosecutions is a constitutional office, so described, pellucidly clear in its language, at Section 90 of the Constitution. In particular, Section 92, there shall be a Director of Public Prosecutions for Trinidad and Tobago, whose office shall be a public office. Section 93, the Director of Public Prosecutions shall have power in any case in which he considers it proper to do so, A, to institute and undertake criminal proceedings against any person before any court in respect of any offence against the law of Trinidad and Tobago, B, to take over and continue any such criminal proceedings that may have been instituted by any other person or authority, and C, to discontinue at any stage before judgment is delivered any such criminal proceedings instituted or undertaken by himself or any other person or authority. 4, that's 94. The powers conferred upon the Director of Public Prosecutions by subsections 3B and C shall be vested in him to the exclusion of the person or authority who instituted or undertook the criminal proceedings, except that a person or authority that has instituted criminal proceedings may withdraw them at any stage before the person against whom the proceedings have been instituted has been charged before the court. 5, for the purpose of this section, a reference to criminal proceedings includes an appeal from the determination of any court in criminal proceedings, or a case stated or a question of law reserved in respect of those proceedings. And 6, the functions of the Director of Public Prosecutions under subsection 3 may be exercised by him in person or through any other person acting under and in accordance with his general or special instructions. Now, I've taken time to put onto the record the specific provisions of the Supreme Law, Section 90 of the Constitution, to demonstrate that the Office of the Director of Public Prosecutions is the constitutionally described office to deal with the matters which this law proposes he ought to deal with. Secondly, the Office of the Director of Public Prosecutions is one which is constitutionally protected. The Office of the DPP is one in which there can be no political interference. Notwithstanding the ability of a Prime Minister to be involved by way of input into that process, it is certainly not the case that a Director of Public Prosecutions is a political appointee. And dare I say that the history of Directors of Public Prosecution in this country have demonstrated with certainty that it's one of those offices that has withstood the test of time and has not been the subject of scandal in this country. Madam President, it's also important to note that the Office of the DPP is one which is protected by Section 111 of the Constitution, where the Judicial and Legal Services Commission, of course, is the entity to make the appointment, but it is the salaries and allowances of the DPP's office that is a charge on the consolidated fund, and that's Sections 136(4) to 6 of the Constitution. The office holder mechanism of appointment is one which is insulated, and its terms and conditions are insulated from interference. Anchored in the Constitution in Section 90, anchored in the purpose of his powers as so described in subsections 3 onward of Section 90, and then we come to the existing law. Chapter 1201, the Preliminary Inquiries Law, is one which started in 1917. I have heard some of the debate which revolves around whether this is pre-1962 law and therefore saved law, and therefore whether it requires a 3/5 majority, and whether for some reason there's an infringement of Section 4 and 5 rights, or whether there's an infringement of the separation of powers or rule of law doctrine. I wish to say that this matter has had the benefit of very careful scrutiny by the Privy Council. In particular, the Court of Appeal of Antigua and Barbuda was the entity which considered a matter in a well-known case referred to as the Hilroy Humphreys case versus the Attorney General of Antigua and Barbuda. It was a Privy Council appeal, number 8 of 2008, and Lord Hoffman considered a judicial review proceeding brought then by Hilroy Humphrey, which alleged that there was a breach of constitutional rights on essentially 2 grounds, that there was a breach of the process of protection of the law, and secondly, that there was a deprivation to the right of a fair trial. And Lord Hoffman was very careful in the analysis of the law, which did include a certain amount of argument on retrospectivity, but which the Honourable Lord felt did not apply and with which the entire Privy Council agreed. Lord Hoffman was very careful to say, and I wish to put this on the record, prospective litigants, and this is at page 2 of the judgment at paragraph 4, prospective litigants or defendants in criminal proceedings do not have a vested right to any particular procedure, and there will generally be nothing unfair in applying whatever procedure is in force when the case comes to court. That's the Privy Council, which is the final court of appeal in our jurisdiction, considering entrenched rights which are similar to our constitutional rights in Section 4 of our Constitution. The Honourable Judge went further to say, and this is at paragraph 6 of his judgment, and he said this, that Mr. Fitzgerald QC, who was urging the board to come to a conclusion to the contrary that they did, argued that there was a purposive construction to be applied, and he had alleged, that is Mr. Fitzgerald, that Section 3 of the Constitution would be breached. But the board said this, the board does not accept either of these arguments. It considers that the plain purpose of this section was to prohibit two specific types of retrospective legislation. And here's the material bit. There is no justification for giving it a wider meaning. As for the protection of law, the argument appears to the board to involve a circularity. The court then went on to look to the right to a fair hearing as a guaranteed right. And the court said in particular that there certainly was procedural fairness involved in the process. And paragraph 8 says in particular that the board, if it were to accept Mr. Fitzgerald's view, the conclusion starts from the premise that the preliminary inquiry is a part of the trial for an indictable offense, etc., and they refer to the relevant section, therefore requires it to be conducted fairly within a reasonable time. From this, it would be said to follow that the abolition of the preliminary inquiry would deprive the accused of the right to fair trial. I'm raising this to identify the familiarity of the kind of argument which addresses the constitutionality of this kind of law, to say that the Privy Council has considered the very same arguments now being discussed in our jurisdiction in relation to this matter. But the Privy Council was absolutely clear that the committal proceedings are not determinative of guilt, but act as a filter to enable the magistrate to screen out those cases in which there appears insufficient evidence to justify a trial. That's at paragraph 11. And in essence, this case of Hilroy Humphrey is one which sets out very clearly the fact that we are not looking to disturb any entrenched rights. Antigua and Barbuda had a similar situation. In 2008, the Privy Council considered that position and did not agree with the perspective offered then. The courts in our jurisdiction have been utilizing the preliminary inquiry legislation since 1917. The Preliminary Inquiry Act does provide for certain methods and approaches, the strength of which we have sought to maintain by the clauses which we have identified to be kept in the bill. We have also recognized that, yes, there are provisions which one could argue are statutory procedural provisions which could be attached to this particular argument of constitutional grounding. But the fact is that those provisions, in particular Section 22, Section 23, Section 24, Section 25, and Section 26 of the existing law, the Preliminary Inquiries Act, those particular procedures are merely guides to procedural conduct which are not entrenched in any supreme law. The law, as it is phrased, does not deal with any transfer of rights from the original or inherent jurisdiction of the courts, such that we would be breaching the separation of powers principle identified by Section 99 of the Constitution. That was in fact the case of the arguments in the R.V. Hines case, where there was a prohibition against transferal of original or inherent jurisdiction in whole or in part as an interference in the separation of powers principle. But it is clear that we're not dealing with that as the case in our section. But when we look to the procedural aspects of the law, we really have now the opportunity to say to the Director of Public Prosecutions, subject to capacity, and that is an obvious point in this bill, is there a capacity for the Director of Public Prosecutions to do that which the magistracy was doing? And that is a genuine question which we have in summary addressed by improvements to the office of the DPP, and I will speak to that in detail as I propose to wrap up the debate. But in summary, I can say bodies have been provided, promotions are in gear, 3 brand new offices have been implemented, new case management structural provisions are done. But prosecutions, which are handled 95% of them by the Trinidad and Tobago Police, are also now going to be clothed by having to pass through the DPP's office. The existing law requires, if someone is to face an indictment, it requires a process. You must appear in a preliminary inquiry for an indictable matter. That preliminary inquiry evidence is led, cross-examination, fresh evidence, new cross-examination. The magistrate then decides whether there's going to be a committal. The magistrate transfers that to the Director of Public Prosecutions. The Director of Public Prosecutions must then decide whether to indict or not. So the magistrate goes through this filtration, passes it to the DPP, and the DPP must decide. That's the existing law. When the DPP decides, within his constitutional remit in Section 90, whether he will proceed, he will enter no prosecution and nolli pros, or in fact whether he will just simply let someone go, or in respect of someone who has been discharged and he disagrees, the DPP has the power to take them to the High Court. The DPP has the power to make sure, under the existing law, in Chapter 1201, that he can intervene at any point in time. The DPP has the power, whether a preliminary inquiry has started or not, to indict and take straight to the High Court. So what we're doing is we are simply anchoring this entire bill in the constitutional power of the DPP and in the expressed and recognized function which the DPP had in the existing law, in particular in sections 22 onward, in particular section 23 of the existing law, where the DPP's power to involve himself is very expressly stated, and later on in section 25 and section 26 of the same law. The question now arises as to a very key point that many people have raised, and that is, what is to be had with respect to hybrid offenses? For those non-practicing lawyers, hybrid offenses are offenses which can be tried either way, either indictably or either summarily. The Summary Courts Act comes into operation here, Chapter 420 of the Laws of Trinidad and Tobago. In particular, when we deal with Part 6 of the Summary Courts Act, we start off by looking at Section 94 of the Summary Courts Act, and we take ourselves to Section 101 of the Summary Courts Act. And Section 94 of the Summary Courts Act is proposed to be treated with in Schedule 5 of the bill. You will see in the miscellaneous provisions in Part 4 of the bill that we're looking to treat specifically with Section 94 of the bill, of the Summary Courts Act. And in the Summary Courts Act, we're proposing to delete, to repeal the positions on Section 94. If I just find the copy of the bill, and I look to Schedule 5, we see in Schedule 5, in number 2, the consequential amendments to the Summary Courts Act, we look to Big E, we're repealing Section 94, and then we are in Big F, amending Section 100, Subclause 2 of the Summary Courts Act, Chapter 420. And let me explain what that means. Section 94, which deals with summary trial of indictable offenses, Part 6 of that law still stays. We're eliminating, by way of repeal, the references to Section 94, and Section 94 is the power to reduce a charge from indictable to summary offenses. And it reads, whereupon the holding of any preliminary inquiry on a charge of an indictable offense, the magistrate is of the opinion that the evidence establishes or appears likely to establish the commission of summary offenses of like kind to the offense charged, the magistrate may, if he thinks fit, and unless the DPP otherwise directs, inform the accused person accordingly, and all further proceedings in the case thereafter shall be the same as if a complaint had been made against such person for such later offense. So we're taking away the ability of the magistrate to convert the matter down. This is going to be a function of the Director of Public Prosecutions, and the bill specifically provides for that to be, in fact, a matter for consideration by him, where he can consider an indictable matter taken to the High Court to, in fact, be one for summary treatment, and he refers it to the magistracy. The important correlation to that is in the amendments to Section 100, Subclause 2, and 100 of the Summary Courts Act is the summary trial of a complaint against an adult for certain indictable offenses. The certain indictable offenses are referred to in the second schedule to the Summary Courts Act, and they list out all of the scheduled offenses that are described there. And Section 101 says, the following provisions of this section shall have effect where an adult a person appears or is brought before a court on a complaint charging him with any of the indictable offenses specified in the second schedule. We are deleting the reference to the preliminary inquiry contained in Subclause 2. So in essence, we're proposing to treat with the scheduled offences in the Summary Courts Act, Chapter 420, referred to by Section 100, Subclause 1, and treated by 100, Subclause 2. We're proposing that those scheduled offences be matters that the DPP will consider, and we're proposing that the Section 94 ability of a magistrate to convert the matter down to a summary offence be eliminated entirely. So the DPP now takes ownership of the entire matter, which respectfully we submit is the purview of the DPP under Section 90 of the Constitution in any event, as specifically stated in the express language of Section 90, Subclause 3, Subclauses 2 and 3 in particular. That is the mechanism to try to translate this bill. Because the average person on the street wants to know, well, what is this bill all about? How does this affect me? What are these lawyers talking about? Very often it's hard to explain the law to the common and relevant person, the ordinary man in the street. But it is the ordinary man and each and every one of us that are the victims of crime or participants in the process. And it's true to say that not every solution is to be found in one off venture. The honourable members of the Senate will note. Thank you, Madam President. The time in the House is a little bit longer, so thank you for the reminder. Honourable senators will note that we have taken a very dedicated approach to dealing with the criminal justice system. We haven't sought to treat with one cog of the wheel. We've sought to deal with multiple areas. Some of them are legislative, as we have seen in the period before the recess, which honourable senators are well aware of. Some of them are operational, for instance, in ensuring that the Director of the Public Prosecutions has the staff, has the capacity, has the ability to operate. That is an operational aspect. One of the pseudo-operational but subsidiary legislation aspects is the implementation of the criminal proceedings rules, which came into effect on the 18th of April 2016, which we had talked about for many, many years, but which is now in the system and being worked out in similar fashion, not in the perfect sense of the word, but as the civil proceedings rules cause a radical transformation of the civil backlog, so too will the criminal justice rules, the criminal procedure rules have similar effect as we begin to comply with the obligations and as judges and magistrates become more familiar with the extent of their powers and apply the unspecified sanctions in the process. But the fact is, we know that preliminary inquiries take far too long. I don't want to go into any sub judice rule, but suffice it to say there is a well-known case before the courts dealing with an allegation of serious corruption. I'm referring to the Piarco Airport inquiry, and all that I will say about that is that it's been in the magistracy since the year 2002. We're in 2017. We are in the preliminary inquiry stage to decide if we have a case that should go to the High Court to then start trial, and after High Court, Court of Appeal, Privy Council, and then we find our way. I make no submission as to guilt or innocence. I'm looking at the time frame factor there. Because there are positions on both sides. Persons accused want the benefit of being held to be innocent. Because allegations are a terrible thing in our country. We write a letter to the Integrity Commission and that means it's true. Whatever you write. The Integrity Commission is bound by hands and legs and can't say a word about it, but the letter speaks for itself. Whatever it is. I don't not understand this. As a person in public life, you subject yourself to criticism and ridicule, and a very healthy amount of it, but that's our process, and we've put ourselves into this mix, and we stand by it. But my point is that persons want vindication, and also persons want justice. Which way it is can only depend upon due process, as the leader of the House was saying a little bit earlier. Due process is that critical thing which takes our society into discipline. Cause, consequence, effect. Can law make this better? Perhaps. Can law change morality or society? Perhaps it can influence it, as we saw with the speed limit. But the fact is that we have been tinkering with this system for far too long. And the government's submission to the honourable members of the Senate is There are multiple views as to how this ought to be done. Do we take the St. Lucia model like 2011? Do we take the Antigua model like 2014? Do we take the Bermuda model as is now being offered as a solution? Do we go to the English model where the magistrates still have some involvement, particularly for triable either way or hybrid offences? Our submission, having the responsibility for governance for the time frame that we have, and it's 36 months and counting. We count in months. How fast 60 months has turned to 36. So, Madam President, as I know my time has properly run out, there's a lot that we wish to hear. There's a lot that we wish to consider. We consider the views of honourable senators as important, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Abolish Preliminary Inquiries and to Provide for the Pre-Trial Procedure in respect of indictable offences and for ancillary matters be now read a second time. Senator Sturge.
Thank you, Madam President. Madam President, I listened to the Attorney General intently for the last 45 minutes, and I am still waiting to hear the exact reason being proffered as to why certain sections of the existing preliminary inquiry model is being removed. You see, we keep making reference to cases being stuck preliminary inquiry mode in the magistrate's court, and the Attorney General made reference to the airport case. And when we make mention of this, it seems as though we are not offering anyone an explanation as to why these cases are taking so long. You see, I would be the first to admit that something needs to change with respect to the existing model of preliminary inquiries. We have had it for 100 years, and I'll say immediately when things started to go wrong. From 1917 until 2008, you had what still exists to some extent, which is referred to loosely as the old school preliminary inquiry, where witnesses are called to give viva voce evidence in chief, and thereafter they are subjected to cross-examination. In 2008, a new system was ushered in, which deals with paper committals, and it still exists. And that is exactly where the problem started, because paper committals were introduced with a view to shortening preliminary inquiries. And how would a committal proceeding shorten the old school preliminary inquiry? It was felt that what you did, instead of leading evidence in chief orally or viva voce from the witness, what you did was you simply filed the witness statement so that he doesn't have to come and give evidence in chief orally, which would take perhaps an hour or two per witness, and thereby the cross-examiner or counsel appearing for the accused would then say, you filed 50 statements, I am interested in cross-examining 2 or 3 of your witnesses only. So you no longer need to call 50 witnesses to give evidence in chief orally. That was the reason why preliminary inquiries started being protracted, and measures were put in place trying to reduce the time. That is, that system, ironically, lengthened the process. And it lengthened the process because prosecutors are required to file witness statements and have them sworn before the justice of the peace. But what happens now with the existing preliminary inquiry is the prosecutor has to, in essence, link with the police officer and link with the witness and link with the justice of the peace so that their timetables are all synced so that the statements are filed. And only after the statements are filed and then taken before the magistrate and admitted into evidence, thereafter you have an opportunity for cross-examination. Well, I tell you, Madam President, I was in the magistrate's court yesterday, and it wasn't my clients, but I saw 2 cases. One, 4.5 years now, and the prosecution
have not filed their witness statements. The other, close to 5 years, and the prosecution has not filed their witness statements. In spite of lawyers being present representing the accused chose to speak for themselves. To say, look, ma'am, I am here 4.5 years. I am here 5 years. This is unfair. The prosecution is never ready. And you know what the magistrate says? Well, we'll adjourn for one last time. And when you check the record, one last time, it has been adjourned for one last time about 15 or 20 times. So there really is no one last time. It is one last time ad infinitum. So you are at the whim of the prosecutor. But what we heard today, we didn't hear that. We didn't hear the reasons why the existing models, be it old school committals or paper committals, why they are more protracted than they were in the past. We heard about what is being removed. And what is being removed is cross-examination. So you would swear that cross-examination is that which causes preliminary inquiries to be protracted. And it is not. Because let me tell you why, Madam President. At a preliminary inquiry, the prosecution really has to make out a prima facie case. That's it. The magistrate cannot discharge the accused cannot be committed if cross-examination impugns the integrity of the material witness. That can't happen because a magistrate is not there to judge credibility. The cases of Jermaine Bowen and David Abdullah make it clear that you can only be acquitted on a no-case submission if an element of the offense is not made out, or if there is evidence such as videotape evidence which makes the allegations impossible, or if there is scientific evidence which shows that what the witnesses is saying could not have occurred. That's the only way. So cross-examination in the magistrate court does not take years. In fact, yesterday in that same court, I cross-examined 5 witnesses in 1 hour. And there are 28 or so witnesses in that case. So cross-examination is not the cause of preliminary inquiries being protracted. And let me just say, I hear what the Attorney General has said with respect to Hilroy Humphreys. And the thing is, cross-examination, whilst Lord Hoffman is saying you do not have a right to cross-examination pre-trial because you get to cross-examine anyway at the trial, when you read Hilroy Humphreys, it is clear that it can be distinguished from what we are debating here. Because what was raised in Hilroy Humphreys, the accused was saying, what is being taken away from me is a protectional safeguard, an opportunity to test the case against me. And with that opportunity, an opportunity where I can be discharged at the magistrate's court without having the burden of these charges hanging over my head for a few more years, without the expense of a trial, and so on. So cross-examination, it's not a right, but it is a protectional safeguard. But the Attorney General made mention when he was saying there's a twin purpose for preliminary inquiries, was very careful to mention disclosure. Now, disclosure is another protectional safeguard. And cross-examination allows a cross-examiner to unearth material that is within the bosom of the prosecutor or the police and being secreted away from the accused. So when you remove the right of cross-examination, you remove the right and the ability of the accused to unearth or to get things disclosed that he, if you remove it, he wouldn't have that opportunity. Now, in 2011, there was an attempt to do away with preliminary inquiries. The Attorney General mentioned that. What the Attorney General did not mention or failed to mention is this. In 2011, there was still a procedure. Although you no longer had the right to cross-examine, there was still a procedure whereby your lawyer had the opportunity to look at the depositions or the papers disclosed and to make submissions and to say that no case is disclosed with respect to one or more of the offenses charged against the accused. In 2014, when there was another attempt to do away with preliminary inquiries, And I think the 2011 model had something called a sufficiency hearing. So although there was no cross-examination, you still had an opportunity at a sufficiency hearing to make legal submissions and therefore avoid a trial if your case is thoroughly bad. Avoid the expense and all that goes with it. So that's the 2011 and the 2014 model. What the Attorney General must tell this Senate is this. In all of the jurisdictions where preliminary inquiries and such procedures have been abolished, it has been abolished, but the substitute was that protectional safeguards were put in place. So let's go to the United Kingdom. The United Kingdom operates under a regime of full disclosure. And they operate under a regime of full disclosure because you can no longer cross-examine in most cases at the committal proceedings. So how do you get disclosure? They give it to you. They give you all of the material. It's no longer at the discretion of the prosecutor, who is a party to the proceedings. And that came about because of cases like the Birmingham 6, the Guildford 4, and Maguire's, and so on, and a host of other cases, which showed that although we trust the police and we trust the prosecutors, they are human. And sometimes, either by error of judgment or deliberately would secret away evidence that may assist you in your defense, evidence that may undermine their own case. But here we are, abolishing that part of the preliminary inquiry, removing the jurisdiction of the magistrate, or at least the judicial function of the magistrate, and the magistrate in this new model is merely an administrator who deals with adjournments and giving directions as to filing witness statements and so on. A case manager, as my colleague Senator Ramdeen is saying. And what is, well, there's so much that is bizarre about all of this. But I'll go to a few clauses to make my point. If you look at, and then I'll speak generally. If you look at section 14 under the rubric pre-trial procedure, it says in essence, the police shall submit to the director of prosecutions, let's deal with B, any statements of witnesses in support of the charge. Well, what does that mean? It means the police officer has a discretion where he can decide not to submit to the Director of Public Prosecutions statements that do not support his case, statements that may undermine his own case. And I pause here to make reference to a case called Jovan Maxwell, because I would have thought that in dealing with this case, you would look at issues like this. Because in Jovan Maxwell, there was a witness who basically materially contradicted the main witness who said Jovan Maxwell was the man who did the shooting. That witness was a witness who was independent, had no interest to serve. The complainant, the police officer, decided this doesn't help my case. In fact, it undermines my case. And he decided, he admitted in cross-examination, it was his decision not to give it to the DPP. Jovan Maxwell had to go through a preliminary inquiry and 3 trials. 3 trials where he could have been convicted and sentenced to hang for murder. And when at every stage, first, second, third trial, you make an attempt to call this witness because cross-examination at the magistrate's court is that which unearthed the existence of this witness. But when it came to the trial, the witness can't be found. That's the first trial. Second trial, witness can't be found. Third trial, witness can't be found. Is that fair, Madam President? It cannot be. And I can give so many cases where that is the case. So here we are, section 14. You are giving the police officer the power to withhold evidence because it doesn't support his case. Madam President, that is something that the DPP should decide upon. And I shudder to think that we should remove that opportunity from him. Because the DPP himself is a protectional safeguard against the excesses of the police. So, evidence that might show you are innocent, the DPP never sees it, you go to the gallows. That can't be right. And you see, the thing is, let me move on. There's so much I can say about this check and balance, but I only have 40 minutes. I have another problem with 15, clause 15. Clause 15 tries to say, in essence, that directions would be given and as to filing of statements and service of statements and exhibits and so on, which the prosecutor intends to produce at the trial. That's what the police gives to him. But there are no sanctions in clause 15. So clause 15, I thought we would have had a clause 15 which would make impossible what I spoke about yesterday, which is prosecutors for 4 and 5 years not yet filing statements. That is the problem that needs to be corrected. I am saying, yes, you need to fix the system of preliminary inquiries, but you can't fix it by leaving gaping holes like this to continue. Because if there's no sanction, then the DPP would go on, his officers would go on ad infinitum with a legitimate excuse. We can't allow this case to be dismissed because there's a victim, someone was murdered, he has family, and so on and so on. But the other thing is, you have a man languishing in prison 4 or 5 years. He's presumed innocent. But you know something? What if he is actually innocent? Because there are those cases. That's 4 or 5 years that he'll never get back. So clause 15 is something that must be looked at carefully and fixed. The Attorney General in his in moving this bill, made reference, again, he made reference to 14, 15, 22, 26. I've dealt with 14 and 15. There's a clause 22. Clause 22 is the PNM's version of section 34. Now, there's two parts to clause 22. Clause 22 deals with, in essence, it removes the power of the magistrate. Clause 22 is an ouster of the jurisdiction of the court, because as it is in the existing system, the magistrate has to make a determination as to whether a prima facie case is made out. In the 2011 version, which was never operationalized, you still had a judicial officer at a sufficiency hearing. There's no sufficiency hearing here before a judicial officer. So you are removing the ability to cross-examine, you haven't fixed issues of disclosure, and you are removing the judiciary from the process. And what is bizarre is this: the DPP, in cases of serious offenses, indictable offenses are serious offenses, the DPP is the one who will be liaising with the police in the first place and giving instructions to charge. So if he gives instructions to charge, and then after 12 months after the magistrate says you are formally committed to stand trial, and the DPP has to look at the docket again and decide whether to prefer an indictment. Same material. He looking at the same material that he used to charge in the first place. Right. Nothing has changed because you had no opportunity to cross-examine. And you had no opportunity to cross-examine. The old common law rules of disclosure still remain, so that's the second safeguard gone, and then the third safeguard, which is the court, is now gone, and you are left with a DPP who is saying, in what circumstances would he hold himself to be wrong? If when he first gave instructions to charge, he said yours enough. Because nothing will change in the interim. So this 22-1 is a farce. And it is a dangerous development. So I would ask the Attorney General to go back and look at the 2011 and 2014 models and bring back into this mix the court. Because the Attorney General said it's twofold: disclosure, and the other thing is filtration, because the preliminary inquiry is a process designed to filter out cases that are bad and shouldn't go before the assizes. But there's a 22-2. 22.2 is the PNM section 34. 22.2 is where the DPP has 12 months, within 12 months of receiving the documents from the magistrate, he has to prefer an indictment. And if he doesn't, the accused can make an application before a judge to be discharged, to go home, to win his case. That was Section 34 that they made a big song and dance over. They had a big problem with. And they are bringing back Section 34, but they name it Clause 22. Sorry, 22. Now, what is wrong with this? Let me tell you what's wrong with this, Madam President. Firstly, right now, I outlined the DPP takes, in most cases, 4 or 5 years at the magistrate's court to complete that process. Then, as it stands, when you are committed to stand trial, whether it's old school committal or committal proceedings new style, the DPP on average takes between 3 and in some cases as much as 7 years before he files an indictment based on on the committal bundle sent to him by the magistrate. He takes 3 to 7 years because he is short-staffed. He cannot handle that volume. So even if you triple the staff complement of the DPP's office, even if you quadruple it, you still have Clause 15, where you can make applications for extension and go on ad infinitum, and the matter stays at the magistrate's level for 3, 4, 5 years because the magistrate ain't throwing it out. And if he throw it out, there's a provision to bring it back. Magistrates hardly ever throw out. In fact, recently they threw out a case, and the Attorney General made reference to it some time ago. But when they threw it out, you know what happened? They threw it out because the prosecutor was tardy, wasn't doing her work, dilatory, contumelious delay. They threw it out, and then they re-arrest the man. So he back inside. So waste of time throwing it out. So you have this new procedure coming here, where you don't fix anything at the magistrate's level. You can go on ad infinitum, and then when you send it to the DPP, he has 12 months to prefer an indictment, which is good, but impossible, impracticable with his existing complement of staff. He can't do it with 3 times the staff he has, and he can't do it with 4 times. So you are not going to... Yes, he can't satisfy 22.2. But the interesting thing is, what if there is a case, somebody who has powerful friends? He might be able to get it thrown out after 12 months. It might be a financier of a political party, not ours. Somebody with oil and so on. And the whole point is, he could get justice before everybody else. And you see the differences. The differences in Clause 34, Section 34, which they had a problem with.
They voted for that too?
Yes. No, they had a problem with it. In Clause 34, Section 34, which they had a problem with, Section 34 said that application is 10 years. So it must be 10 years of doing nothing before the case is dismissed. Here we have 12 months. So if you can't fix your business in 10 years, how are you fixing it in 12 months? But you know what troubled me and what worse than that? With Section 34 that they complain so bitterly about, Section 34 said that clause does not apply to blood crimes. It don't apply to murder. It don't apply to white-collar crime, and so on. This makes no distinction. So you can have a man, Right. So the short point is, they make no distinction so that you could get away if the DPP and file in 12 months. That can't be right. So this is Clause 34, Section 34 brought back. And now we have the other section referred to by the Attorney General, Clause 26. And the Attorney General, in referring to Clause 26, made reference to hybrid offences. Now, what is a hybrid offence, Madam President? A hybrid offence is referred to as an indictable offence which is triable either way. So it is by nature an indictable offense. Not all indictable offenses are hybrid offenses, but there are categories of indictable offenses where the court would say, listen, you want to go to a judge and jury 15 years down the road, or you want your case done before this court, where you could actually plead guilty and get it over with, or you could get a trial before the magistrate. And when that happens, it is because it is a marrying between sections 94 and sections 100. So this indictable offense or serious offense allows the DPP to make a recommendation to the accused. And when he makes the recommendation that, listen, you have a right to trial by jury, but you know what? By judge and jury, you can elect summary trial. And the magistrate will read that out to the accused, and the accused can decide, I am consenting to be tried. I'm giving up my right to be tried before a judge and jury. I would like to be tried before the magistrate. Or he can say, magistrate, one person, case hardened, not me. Let me take my luck before the 9 or the 12 good and true citizens. Because he has that right, as the magistrate would now tell him. You know what this clause does? This clause does, it says in essence, that is not the magistrate, you know. They remove the magistrate. The DPP is now the one to make that determination. Isn't the DPP a party to the proceedings? So a party to the proceedings who has an interest in sending you to jail can now say, look, don't bother with that, you know. We don't want to try Ram Logan before a judge and jury. We feel he will get away. We go and try him before a magistrate and tell the magistrate, here what happening, you have to try Ram Logan. And it's a fictitious Ram Logan I'm speaking of. Ram Jack. We say Ram Jack. Yes. Yeah, I don't want to say bash. But the whole point I'm sorry. I'm so sorry. But the short point is, why are you, again, removing a magisterial power and giving it to a party to the proceedings to determine how you ought to be tried? Because under the existing setup, you consent. So why are you removing the ability of the accused to consent, to say, look, I could take my chances before the magistrate, or to not consent? That can't be right, Madam President. Now, there are a few more issues that I would like to refer to generally. You see, I know at some point someone else may point out that I was one of the persons who advocated for the removal of preliminary inquiries. I did so in my motion on rising crime earlier this year. But I would like to remind whoever is going to refer to it to look at where I mentioned that, because I mentioned it under the rubric medium term. Because you cannot get rid of preliminary inquiries in the short term. I see Senator Rambarat has thrown away part of his speech now. Yes, I did say it, because the truth is, preliminary inquiries, as they are now, must be fixed. But before you fix them, you must do like other jurisdictions have done. Before fixing it, there were other systems that were put in place to ensure that when that system was removed, that the system would actually work. You see, let me tell you another thing that happens with preliminary inquiries that has started happening since 2007, 2008, thereabout. Before we have the committal proceedings, which we now have, witnesses had to come and go into the box and give evidence and be cross-examined at the preliminary inquiry. Now, Since 2007, there's a 15C of the Evidence Act, which says in essence that the prosecutor doesn't have to call a witness if the witness says he's in fear. Well, we understand if the witness is dead, you can't call him. We understand if he's very sick and can't attend, you can't call him. He's out of the jurisdiction, you can't call him. But witnesses, all of a sudden, since 2007, since that was passed to now, all of a sudden, nobody wants to testify. The police can't find witnesses. In fact, they came with an application recently, witness can't be found. And I saw the witness outside the substation in San Juan. I had to go and tell the magistrate, the witness turned up yesterday. Because I find him. And he's standing up outside the substation. He's mentally ill and dancing, probably rant of a madman. And I saw him, and I had to take my cell phone and videotape him. Had I not done that, it would be my word against the police officer who's saying he can't be found. And I understand why he wouldn't want to be found, because he's obviously a coke addict and he wouldn't support their case. But all of a sudden, you have these plethora of applications in the magistrate's court which stretch out the committal proceedings. So you have applications which are separate to the substantive preliminary inquiry. You have to make an application before that statement of that witness is admitted into evidence. So all of a sudden, you can't find witnesses, everybody in fear. So then you have applications, you have to call 4 and 5 witnesses per application, so it mushrooms. Another thing, prosecutors are making bad character applications at the magistrate's court. And the thing is, and that came in since 2009, bad character is not something which the magistrate would use to commit you to stand trial for an offense. Bad character is something which is led before a jury, because the credibility of the accused is an issue. The credibility of the accused is not an issue at the preliminary inquiry, because that has nothing to do with if a prima facie case is made out. But that is what the prosecutors are doing. So more delay, because you have to come and prove that he has all these convictions and what he did and bring witnesses to support it. And you have to cross-examine and you have to make legal arguments. And that is why it has stretched out. And that is what we need to fix. Then there's disclosure. I begged the Attorney General when we did, what was the name of the plea? Yes, thank you, plea. I begged. And I'm begging for this reason. Whilst we are speaking about magistrates' court, it is even more of a problem in High Court. Because let me tell you why juries are acquitting. And let me give you a case again. When the police, when you cross-examine the owner of an establishment and he tells you that the police sees the videotape showing the incident, and the police never disclose that, and the jury hears that, and you are making an allegation that what happened is the police were shooting at each other, it was friendly fire and somebody dead, it wasn't the accused, and the jury hears that, then the jury quite naturally would want to know, why was that not disclosed? Is there any good reason? And that is enough to cause reasonable doubt, which leads to an acquittal. So I beg today, I implore, I go down on my knees and ask the Attorney General, it can be fixed right here in clause 14 by saying the police must submit all of the material gathered during the course of the investigation of the offense. Let them submit all. And I'm still saying, even though they submit all to the DPP, and the DPP would have a discretion under common law, I'm saying at some point we need to look at the common law, because the common law gives the discretion to the prosecutor to decide, the prosecutor who has an interest in convicting you, to decide whether something he's secreting from you, whether he should give it to you. And he'll say, I can only give it to you if it assists your defense or materially undermines my case. And this is Trinidad and they are humans. So why go through that? Because you see, the thing is, we no longer have cross-examination once this bill is passed and proclaimed. We no longer have that safeguard of cross-examination at the magistrate's court that would unearth and force disclosure. But you know what? When it comes up at trial and you don't have full disclosure, again, an opportunity to parade in front of the jury, and the jury would ask, why is the police behaving like this? Or why is the DPP behaving like this? In the United Kingdom, after Michael Hill QC's behavior, and a distinguished QC, former MI5 member. No one thought he would have behaved the way in which he behaved in the Guildford 4. But that discretion was removed. So what we need to do, we accept that you don't need to give the names of informants. That's not part of full disclosure. That's a security issue. You don't have to give names and address of witnesses, but you need to give the material, the evidence, all of the evidence gathered. If you are removing one safeguard, which is cross-examination, which assists in disclosure, then replace it with another safeguard, because you have already moved a safeguard in the form of cross-examination and in the form of legal submissions before a case master or the sufficiency hearing. I did. Now, one of my colleagues, I'm sure, would refer to the powerful speech given by the Member of Parliament for Maraval, it's Maraval they call it, or Diego Martinez, Mr. Imbert, in 2011. Because Mr. Imbert said, you can't abolish preliminary inquiries in the short term because you have to build more courts. Because you are shifting a bottleneck from one place to another. When you remove the preliminary inquiry, which holds back all these thousands of cases from the High Court, you remove it using this process, and you put all of these cases to the doorstep of the assizes. What is going to happen? The assizes, which has 6 courts in Port of Spain and 3 in San Fernando, and 1 in Tobago. In fact, I heard the Attorney General in another debate make reference to the fact that the High Court in Port of Spain only did 39 trials. 39 trials a year. There are hundreds of trials waiting. And then you are going to remove this, and then hundreds more. The minute you're charged, within 12 months, potentially, you could end up by the door of the court, with the possibility of jumping the queue in front of others who have been waiting for 15 years. That can't be right. So when are these cases going to be heard? Yes, okay, move the preliminary inquiry. And then what? Then we have a cause list every day with hundreds of prisoners. And when are they going to be tried? By 6 judges. When a trial lasts 2 months on average. So I know other colleagues would develop that issue, but I am thankful that the Member of Parliament, Mr. Imbert, in 2011 recognized the folly of abolishing preliminary inquiries without putting things in place. You have to build more courts. Have you built more courts since 2011? You haven't built any. So how is this going to work? How is this going to make sense? And you know, the thing is, I heard the Attorney General speak about trying to deal with crime. The preliminary inquiry doesn't deal with crime. This is not a crime-fighting measure. I listened intently. I heard a lot of statistics. I didn't hear reasons for amending the particular sections, what was wrong with them that needed to be amended. I heard a conversation. And these days we are hearing conversations with the Prime Minister, and now today we heard a conversation with the Attorney General. We haven't heard an analysis. And I'm not suggesting analysis paralysis. I'm just suggesting that we pause for a cause. Before we remove something without any proper system in place. If you think what is termed the Marcia 53 are getting on bad, that's what they call it in the newspaper, the 53 who have to have their cases do over. When this happens, you'll be having riots every day. That can't be right. So pause for a cause is the word for the day. Now, and I am reminded that a Member of Parliament, Imbert, was successful enough with his forceful arguments in that regard, so forceful in his arguments that he was able to extract an undertaking from the then Justice Minister not to proclaim the act until more courts were built. So is this another piece of legislation that we are going to pass and just put on the shelf to say, well, we did some work? I have to ask. Can I ask how much time I have,
2 minutes.
Madam?
2 minutes.
Oh, that's 30 seconds.
Let me see. DPP can't cross his focus. I think I don't believe I can develop these other points in 30 seconds. So, Madam President, I thank you for the opportunity to join in this debate, and I look forward to meaningful discussions and camaraderie when that time comes in the committee stage. I thank you.
Senator Choate.
Thank you, Madam President. I don't know if there's something wrong with the audio in the House, but it seems to me as though there is a bit of reverberation and the sound is coming across very loudly. I don't know if it's just my hearing that's going or if there's something that could be adjusted, but I'm wondering if perhaps that could be done. Now, what I had hoped to hear from the Honorable Attorney General in presenting this bill to the Senate, instead of statistics coming from certain reports which have not been identified to us, and really which don't help us, because we all know that loads of cases go through the magistrates' courts, I would have liked to have heard information about what concrete steps, if any, have been taken to ensure that the Director of Public Prosecution's office is now capable of doing or operationalizing, as the Honorable Attorney General likes to say, what he is mandated to do under this proposed piece of legislation. I do not think, with all due respect, Madam President, that it is fair to the Senate to ask us to support a piece of legislation by saying that I will give the justification after the debate has, or when I wrap up in the debate. I don't think that is fair at all. And I wish that a different approach had been taken, and in the future, I hope that such an approach will not be repeated. Now, this piece of legislation fits in nowhere in the fabric of legislation which governs criminal procedure and practice in Trinidad and Tobago. And I don't even, in fact, I am disappointed that we should have to start a new term with this piece of legislation, because I think everyone would have been much more upbeat if we had had to look at a piece of legislation which was capable of working. Now, the Honorable Attorney General, Madam President, has gone into some detail to say, or to talk about the similarities between the old legislation and the new. Well, I regret that that really doesn't help us, because if you have something new, why do we need to spend 10 minutes on hearing about how similar it is to the old? So let us look at the material parts of this piece of proposed legislation. Let's start with pre-trial procedure. And Section 14 says that wherever any charge has been brought against any person for an indictable offense, the police shall submit to the Director of Public Prosecutions a list of things, A, B, C, D. Now, if the police don't do it, what is going to happen? What is going to happen to the case? Is it going to be hanging in midair? Is there a time frame within which the police must provide this information? Unfortunately, these things, or the mechanics for this section to work, have been entirely removed. So all we have is an assertion or a mandate to the police to provide the information to the Director of Public Prosecutions. As someone who practices at the criminal bar, I can say that the police take their fine time to provide material to the Director of Public Prosecutions. In fact, in Rio Claro, in a matter in which I am engaged, I'm not going into the merits of it, but this man has been waiting about 1 year for his file to leave the police. Every time I go to court, the file is with another police officer. It has not reached the office of the director in 1 year. Now, of course, we can take steps and we can write to the director, and if he does nothing, we can perhaps judicially review and so on. But all of that is adding to the time that my client is going to be spending in custody. So there must be some legislative mechanism put into place to ensure that the police must comply with time frames, and if they don't, there will be sanctions. Now, Section 15 goes on to say that the Director of Public Prosecutions, within 3 months of receiving these documents, has to serve the accused person or his attorney at law with the documents which he has collected. If he can't do it within 3 months, he makes an application to the magistrate to give him an extension of time. Okay, well, I would have expected to see here in this kind of legislation, as we see in other similar kinds of legislation in criminal law in this country, we will say, okay, you have to make your application within a certain period of time. The magistrate is not allowed to grant an extension for more than 1 month unless there are exceptional cases. And if you don't comply, if you get your extension and you still don't comply, what is the impact of that? Again, it is like having a toy for a child with the engine taken out or the battery taken out. You just look at it and it looks nice and it's colorful and so on, and there is nothing to make it work. Now, I must say, looking at this legislation is depressing. It simply does not make sense. Look at Section 16. An accused person or his legal representative may, within 3 months of being served, or within such further period as a magistrate may on application permit, serve on the DPP. And what we're talking about now is serving on the DPP, his defense, his witnesses' statements, his documentary exhibits, his alibi notice. Well, we can exclude that because that is already part of the law. So I will make no big deal about it. And his list of exhibits. This is not a procedural issue. The Honorable Attorney General, Madam President, may seek to suggest that by saying that the accused person may, within 3 months, serve on the DPP these documents, all that you are doing is you are facilitating the accused person by allowing him, if he wishes, so he has an election, if he wishes to hand over his entire defense to the other side. I don't know anyone in their right mind or any attorney worth his or her salt who will advise any person to hand over his defense to the police. And the reason for that is when I look at further down in the Act, I see that when this is handed over, all of this is kept by a prosecuting authority, either the Director of Public Prosecutions or the police. Now, am I, with a modicum of common sense, I hope, am I going to be advising someone to not only hand over all the material, the original material that you have, which would include, for example, if the police shot you and the doctors took out a bullet, that bullet, would you hand that over to the police to keep for you until trial, when there is no time fixed for trial? When your trial may be in 3 years' time? When there is nothing specified in the legislation to say where these items must be kept? What are the safeguards in relation to things taken from an accused person or from the defense? What are the penalties if you lose it, if you destroy it, if you come to court and say you can't find it without an excuse? And these are issues which affect fundamental rights and liberties. So let us not pretend that this may here in section 16 allows you an option. There is no option when you look at the legislation as a whole. Now, if I may move on to section 17, we have a reference to statements being taken by children and so on. And after all that we went through with the legislation at the end of last term, particularly through what I have to say, the tortuous month of June, I thought that we would not find something such as this in section 17, subsection 4. This subsection says, notwithstanding section 98 of the Children Act 2012, where a statement is made by a child under 10 years of age, such statement shall be supported by a statement from a probation officer, a child psychiatrist, or any other person qualified to make an assessment of the child to assist the court to determine whether the child is possessed of sufficient intelligence to justify the reception of a statement as evidence. Now, don't we know enough about the world and about law to understand that they are experts in very many fields, but certainly the expert who is most appropriate to do the assessment or the adjudication that you are asking for is not mentioned in this subsection. There is no mention of a child psychologist who is the only person, perhaps, or the best person who can apply the forensic standard and approved tests to determine intelligence. What? Any other person capable of determining intelligence will bring a preschool teacher and say, well, the child couldn't write his name too well in preschool? This is absolute nonsense. Now, I know, having regard to the constraints of time, I'm not going to be able to address all of the issues that I see that we must address in this Senate, but I will try to address the ones which are the most significant. So let us, if we may, move on to section 18. It says here, the exhibits referred to in sections 14, 15, and 16 shall be duly marked. Okay, fine. So we understand now that the exhibits that the legislation is talking about includes the exhibits for the defense, which have now been handed over to the other side. All exhibits other than documentary exhibits shall be taken charge of by the police or another appropriate body and shall be produced by them or it at trial. Now, I don't see anything in this legislation which tells me what is an appropriate body. There is no such thing in law. I can't look to the standing orders even, because the police standing orders, which deal with how the police must treat with property in their custody, they don't talk about appropriate body. So who is this appropriate body that we are talking about here in this legislation? And should that not be defined? And if it finds itself here, we have to know what appropriate body means. In any event, I have already expressed my concern about handing over matters to the police at the early stage of an investigation. I pause here to refer to what Senator Sturge had been speaking about earlier with respect to the issue of disclosure. Now, this piece of legislation has created considerable confusion in criminal practice and procedure because there is very little commonality between this piece of legislation and the criminal procedure rules, which 2016, which have been gazetted and which criminal practitioners and accused persons and judicial officers have been using since then. Now, the criminal procedure rules, and I respectfully say, Madam President, it is no answer to stand up at some point and say that it's secondary legislation. At the end of the day, these rules were the outcome of considerable work by all the stakeholders in the criminal justice system. So these rules provide for full disclosure. It's set out quite clearly what you must do during the course of a high court trial or a summary court trial. You must give full disclosure. There is nothing like that in the legislation. So how are the two going to operate in tandem? Obviously, the prosecution is going to say, well, if the legislation doesn't talk about disclosure, then too bad for you, because the rules are really subsidiary legislation. But we in this country like to glorify what takes place in other jurisdictions and think that those things are made for us. And I will explain this by referring to two examples. Over the course of the last month, a report has come out in the United Kingdom from the Crown Prosecution Service, which says that even there, where you have mandates for disclosure, the police are not bothering to provide the information to the prosecutors. And the prosecutors, for whatever reason, sometimes it may be overwork, and I'm sure that will apply here, but the prosecutors themselves don't have the time or they don't have the interest in pulling the police up and saying to them, listen, the law mandates under the Police and Criminal Evidence Act as amended multiple times that you must give disclosure. The prosecutors are not doing that. So what are we to expect here? What are we to expect here? We are going to have to expect that we have to fight tooth and nail and sometimes embarrass police officers before we can find the material which will be useful to our client's case. Now, why the provisions of the criminal procedure rules don't find themselves in this piece of legislation, I don't know. There's not even a reference to it. There is not even a reference to disclosure and how it will operate as set out in the gazetted rules. There is a total conflict, and I don't know how we can reconcile it. Now, I will continue. Section 21. Section 21 says the documents will be kept by the DPP. Now, remember, this is somebody might be in custody and they might be unrepresented, and their documents are kept by the Director of Public Prosecutions, which up till last year didn't even have enough photocopiers, much less storage space to keep documents of accused persons. And it is said that these documents will be kept by the DPP until the indictment, if any, to which they relate is filed, and shall then be transmitted to the registrar, who shall keep them and produce them to the court at the trial of the accused person. Okay, so we have the responsibility for custody of the documents at some point moving from the DPP to the registrar. What checks and balances do we find here? When does the DPP have to transmit these documents to the registrar? Because it's all confusing. Until the indictment, if any, to which they relate is filed. So what happens if no indictment is filed? What happens to these very important documents which belong to the suspect or the accused person and which he may need to use to sue the state for false imprisonment, malicious prosecution, and the usual kinds of cases which are filed in these circumstances? How is the accused person going to get his material back? Why are his things relating to his defense being taken away from him? You are depriving a man of his liberty and of his right to access the courts in both the criminal and the civil arenas by a section like this. Section 22 says, this is a section I think Senator Sturge had referred to as the Section 34. Colleagues, Madam President, through you, I wish to remind my colleagues that it wasn't one side that voted for Section 34. Perhaps people's recollections should be refreshed. But when we look at 22.2, we see that where the Director of Public Prosecutions does not prefer an indictment against an accused person, within 12 months after the expiration of the period specified in Section 16, or within such further period as a magistrate may on application permit. Let's pause there and stick a pin if we may. So we have the documents already sent to the DPP, and the next logical step is for him to indict and have the documents go over to the Registrar of the Supreme Court. But now, according to this, he can step back and go back to a magistrate who, in my respectful view, has no locus, is finished with the matter if the matter was before him or her at all, because I don't see how magistrates will play a role in this legislation. But you go back before a magistrate and you say, by the way, I'm sorry, I couldn't make the 12-month period. Are you able to do that once? What time is the magistrate allowed to give you after that 12-month period? 2 years? Are you to go back every 12 months? Are there any checks and balances in the legislation for if you fail to comply? Now, what is being given here is tremendous power to an officer who is a public official, but who is also a party to the proceedings in adversarial matters before the court. And we have to understand that when we see the words Director of Public Prosecutions, we are not referring only to Mr. Gaspard Senior Counsel, but we are referring to Mr. Gaspard Senior Counsel and every State 1 attorney down the line who started 2 months ago when we talk about the Director of Public Prosecutions, because anybody who prosecutes from that office prosecutes in his shoes. Madam President, I see that there's a certain blue color appearing on your desk, and I hope that I haven't contravened any of the standing orders in trying to make my point.
Senator Choate, if I may, you're just seeing lots of blue things on my desk, nothing with reference to you, okay?
Madam President, that is indeed a relief. So we have a huge amount of responsibility being handed over to an official, and we are thinking only of the official, but then we ought to be considering all the parties who will exercise his power. Thank you. Now, Section 23 of the Act, and I say I am trying to go through this as quickly as I can. Section 23 of the Act talks about the Director of Public Prosecutions preferring an indictment where not even a complaint has been filed. For example, where you have a coroner's inquest, a person is charged with an offense involving serious or complex fraud. The problem I have with 23A is what provision is there for juveniles? What provision is there for the protection of juveniles to ensure that they are represented, that they understand what the process is, and that their rights are protected? I regret I see nothing here which deals with that. It doesn't even reference another piece of legislation which may address this particular concern. And I don't think it can, because this is a new thing entirely. Now, the next one, 23B, is a beautiful sting in the tail. May prefer an indictment whether or not a complaint has been filed where a person is charged with an offense involving serious or complex fraud. Does that mean that in any ongoing matter, you can pluck it out of the court system and say, okay, I now have the power I can prefer an indictment regardless of whether a complaint has been filed. This is a procedural matter. Retrospectivity has nothing to do with it. Would it not be nice and easy to have that kind of resolution to certain matters which are continuing for a long time before the court? I think that we have to look at the effect and impact of this subsection and understand the use and abuse which may be made of it. I certainly
stage, we will suspend, we'll take the break, and we will resume at 5:30. Senator Choate, you will have 10 more minutes of speaking time.